Honorable, the Supreme Court.
Thank you. Good morning. Please be seated. Please call the case.
Good morning, Your Honors. The matter before the court this morning is the case entitled John Gerlach and Deborah Gerlach versus Town of Chittenden, case number 25 AP 179. Representing the appellants, John Gerlach and Deborah Gerlach, is attorney Mark Hall. Seated at counsel table with attorney Hall is attorney Alex Arroyo. Representing the appellee, the Town of Chittenden, is attorney Kevin Kite.
All right, counsel for the appellant, please introduce yourself and your client, and then you may proceed with your argument.
Good morning, Your Honors. My name is Mark Hall. I'm with Paul Franklin Collins. I'm representing John and Debbie Gerlach in this litigation. I'm here with Alex Arroyo. Some of you may be familiar with him. We come to this very straightforward. I'm not going to try to recite the facts of this case, especially regarding the road, because that would eat the 10 minutes that I planned for. We're going to go right straight to it. From our position is this case is really governed, and where the mistake was made below was by the misapplication of the summary judgment standard to the facts as they stand forth in this case. There is not facts sufficient enough to unquestionably find with clear and unequivocal evidence that there was a dedication of a right-of-way by the
Attorney Hall, let me ask you a question about the stipulation that confuses me. Perhaps you can clarify it for me. The stipulation certainly, I think, intends to reclassify a road. Yes. And there's a temporal argument that you make that the stipulation was only could be in existence while the Marshall, Fishkin, or Orent owned the property. Is that correct?
To some degree, I don't think anybody can say exactly what's there today.
Well, the stipulation says that, but then it says that it also on I think paragraph 16 states that it shall be binding upon the settlement stipulation shall be binding upon the parties to this agreement and their respective heirs and assigns, except as otherwise provided for herein.
Yeah.
So does that mean and I'm trying to understand this, does that mean this stipulation is no longer valid once the property is sold, even though different ownership, even though it's gone through this reclassification process?
That is certainly one interpretation of the that we're making.
That's your argument then?
From our no, we're making also the argument as what was agreed to was not a dedication. It was basically, if town, you have a road.
But does it become an easement then? Let's separate it out from dedication.
I think it becomes more of a license that is it is limited in the time it lasts, or is subject to conditions. I don't think there's any sense of a dedication of a 4-rod road in this case.
Didn't Fishkin give up concede the fact, and the town concede the fact that this ancient road was not going to be a road. It was going to be a legal trail, and it's going to be limited by width, and it's going to be limited by use.
We don't, you can't tell that from the evidence, Your Honor. That's a big point we're trying to make here is where would you go in this case if you're looking to say who gave up what? You'd go to the releases. No releases were ever drafted in this case. No releases were ever signed.
Attorney Hall, when you would agree that the Fishkin Marshall party agreed to the reclassification?
Yeah. No, I would not say that.
Okay.
They did not agree to that at all. They said they would not protest it.
Okay. But they
and acquiescence doesn't apply to dedication.
They allowed it to go through, and they said they wouldn't object to it. They wouldn't seek compensation for it. And in fact, the agreement calls for the town to take those steps to reclassify the trail. And doesn't 301(8), by its definition, say that when something is labeled a trail, it is in fact a public right-of-way?
In this case, for a temporary basis, but we can't discern at this point what did the Fishkin Marshall actually give in this case. Bear with me on this. Yeah. From the Fishkin Marshall standpoint, they said, we don't think you have a road. Town said, we have a road. We don't think you do. Town said, well, we'll reclassify what we think is a road into a trail. Fishkin Marshall said, do whatever you want to do with your imaginary road. We're not going to object to it. But there's no language anywhere in all that's stated here in which the
But then they-
Fishkin Marshall said, we're giving up our argument that there's no road here at all.
But then they dismissed their case, which
It-
was all about ownership and identity of this. record.
Dismissed without prejudice,
Certainly,
Based
but
on stipulation.
based on a stipulation, but the
But-
stipulation requires releases that would have defined, in this case, what was being given up and what wasn't being given up. It just, hold on just for a second.
Go ahead.
What is there now? Is it just a trail permanently? Or is there a 4-rod wide road that the town can later turn to a class 3 road and pave it? You get in a situation here, you can't answer that question based on this record. That is the critical aspect of this case. What the trial court made a mistake here is it supplied the answer as to what the language in that release would be by speculation.
but isn't that a
doesn't-
question?
Doesn't agreeing to reclassify the road indicate that it was a public road agreement by Fishkin?
There is not, you can't look at the stipulation and say that there's any agreement that there was a road in that location. They said they would not contest it for as long as they own the property. But they did it. In this case, this agreement is just a little teeny agreement kicking a dispute over whether an old road exists down the road for the Gerlachs, unfortunately.
So does this, the town then can come in now and say it's actually a road?
I can't tell from this agreement whether they could or not. I certainly would fight that, but based on the agreement, based on the lack of releases, based on a lot of problems with regard to the way this was interpreted, not only in the stipulation by the trial court didn't even answer that question.
Where in the record?
Is there a
does-
trail here or is there a 4-rod wide?
where in the
right
re-
away?
The record does your predecessor in title preserve the right to object?
It's in the agreement. If the town doesn't follow the terms of the stipulation, they have a right to object.
But they
What
didn't.
the subsequent owner can do is nowhere to be found. I mean, we have a situation here where the town,
But isn't that
you-
where equitable estoppel comes in?
pardon?
Isn't that where equitable estoppel would come in if the land is now transferred to somebody else? Whatever rights Fishkin had preserved are no longer alive pursuant to the stipulation? Isn't that where equitable estoppel would prevent?
No, because there was no representation by the Fishkin Marshal that there would be a permanent road across the
Well,
property.
But there was a real estate closing with Fishkin sold to your clients.
Yes.
And your clients were well aware that this legal trail existed on the property prior to the
Mm.
closing.
No, there's a title claim pending, Your Honor, under the title policy. There's nothing in the deeds or anything that indicates this. There is a map that shows a trail.
Mr. Mube said in his, in one of the pleadings or one of the writings that he discussed that with his clients, that there was a trail there.
I'm not aware that there was anything. I know that there's a title claim pending against Caddick. That's all I can say. It's not a part of the record. No, I don't think that there was a road that was shown, a trail shown on the town map. I don't believe it was part of the deed. I could be wrong on that, but I can follow up with that.
But it would be searchable, would it not?
If it's not in the deed, it's not going to be searchable necessarily from the context of looking through the title record. You might be able to see a trail somewhere, but the settlement agreement wasn't recorded.
But Mr. Mube represented Fishkin in the litigation
Yes.
against the town, and then Mr. Mube represented your clients at the closing.
Yeah, and then Mr. Mube is representing the Gerlachs originally in this action, making the same arguments I'm making today, that this agreement didn't exist relative to the Fishkins giving away a 4-rod right away.
Perhaps you can help me here. I'm trying to understand where this right of way comes from and where it goes.
Well, for purposes here, it comes in from off our property on one side and goes off our property on the other. And it kind of goes right across the middle of it.
But are there right of ways on each end?
According to, yes, and when they did the reclassification, the municipalities on both sides were involved. So,
Pittsford, was it Pittsford, Proctor, and Pittsfield?
I think so, yes,
We're all part, it's all in that one little triangle of
Yes.
Chittenden.
yes. I mean, we look at this from a standpoint, once again, back to Rule 56 and the inferences being drawn here. There's two interpretations of this stipulation that are easily shown by by the documents relied on. It's easily shown that Fishkin just said, if you want to put a trail there and that's all you're going to do with it, go ahead. I don't care. I'm not going to protest it. But nowhere am I saying that I'm giving up my argument that there's never been a road there to begin with. You can take your imaginary road, do what you want with it. I won't protest it. That's supported by all the evidence the trial court relied on. That's a reasonable inference. It should be construed in our favor, not in, instead the court went the other way and construed every inference in favor of the town. Now we're looking here with ambiguities here. We don't know what's there today. We don't know what was supposed to be in the releases. We don't know who was releasing what. There's all these questions that need to be resolved. This case went to summary judgment early. The Fishkins and marshals have not been heard from. The people involved in this case for the town have not been heard from. All we have is this stipulation. Stipulation has an inclusionary clause. The merger clause says this is all you can consider relative to this agreement. There's no indication in this agreement stating that Fishkin and Marshall intended to give up any of their claims, any of their arguments at all. If there was a release signed in this case in which Fishkin and Marshall said, we give up our claim that there's no road there in accordance with this agreement, that would be a dedication. That never happened. And that release could say many things. That release could say, we'll let you have a trail. Everything else is still on the table. Or it could say, we'll just give you a trail. None of those things are answered by this stipulation. There's so many facts that need to go back to this trial court on this
Does
case.
that include the fact that it may still be a road?
Yes. And that's not decided in this case. So you can look at the trial court's decision. It doesn't decide. It says there's a public trail there. It doesn't say, hey, what happens to that trail after the Fishkin and Marshall sells the property? Because there's a timing limit on how long the town has to restrain itself from the use of the right of way.
And both parties agree that this road has not been used, correct?
Pardon?
Both parties agree that this road has not been used.
Yes. It's one of those Vermont roads, 1796, and we're arguing about it in 2026. I mean, granted, it can be implicit with regard to the dedication, but it still has to be clear and unequivocal. And there's just too many unanswered questions in this case to say, hey, there's a 4-rod road right away on the Gerlach's property forever.
The appellees argued that you haven't raised the issue of acceptance in your briefing. Is that accurate? Is there anything you can point to in the brief that would argue about acceptance?
Not in the brief in chief, no, or in the brief or in the provided brief. This has been centered on dedication. I don't think the question of acceptance it was determined by the court, but I don't think that the focus has been on dedication.
The landowner is the dedicator, right? The landowner would be the one who would dedicate,
Yes,
and then the town would be the one who would accept.
yes.
And so can't you, based on what occurred here, that Fishkin clearly dedicated this as a legal trail number 10, and the town accepted it, gave him a tax break for 3 years, it was approved by the board of, select board in the town of Chittenden, and wouldn't that be a dedication and acceptance?
I don't see the dedication, Your Honor. You keep going back, say we gave them something. There's not a document, not an email, not a letter, not a communication at all saying that we would concede anything that we're arguing in our lawsuit. We said, if you want to change it to a trail, go ahead. We'll even let you use it while we own the property. That's what the agreement was. That's like a license. That's not a conveyance of 4 rods forever. I mean, it's a big jump from saying, oh, well, you get this little trail to, oh, your property is burdened with a 70-some-odd foot wide road in perpetuity. I don't think that you can see that in this agreement and the stipulation.
In their agreement not to object to reclassification as legal trail number 10, also an agreement not to assert that there's been no dedication?
I think so. I mean, this case reminds me of the Demers decision, where somebody made agreements about, okay, I'm going to do some stuff along a road. It's about to be condemned. And then when they got to the condemnation, suddenly the town said, oh, all these little agreements that you made, that was a dedication. So we don't have to give you compensation. And then try this court.
I think the Demers, if you're talking about Demers versus Montpelier, right?
Yes.
Attorney Hall, I think those facts are very different. And when I looked at it, it was red flagged by Westlaw, so that gave me some concerns. But I think the facts are very different. I don't think this is similar to Demers.
Well, you have to be concerned, and the arguments we made in the case is that at what point can you have an agreement with the town anymore relative to the existence of a road if that agreement's always going to be thrown back in your face as a dedication just because you came to an agreement that you weren't going to object any farther. I see I'm out of time.
Thank you, Council. Please introduce yourself and your client, and then you may proceed with your
I'm
argument.
Kevin Kite, and I'm here representing the town of Chittenden.
So Attorney Takait, I'm going to start right off with a question. I agree that the stipulation shows an intent to allow public use. But I am having a hard time buying that intent to engage in statutory reclassification supports an intent at common law to dedicate. So give me the facts as to why this was intended. The trial court got it right and said that this was a dedication.
Sure. Well, the dedication question is, did the landowner intend to allow public use on their property? That's the dedication question. Because if there hasn't been statutory condemnation and there hasn't been dedication, then a landowner.
Are you talking about statutory dedication?
Yes.
So why,
No,
I think that's irrelevant to this case. And the fact that the trial judge referred to it tells me that he may have been confused and jumbled a bunch of concepts in his mind. So
I don't believe, that was
Okay,
a
good.
general
Help me straighten
statement.
that
That was a
out.
general statement of law. I'm not asserting that statutory
Okay.
condemnation is relevant to this case.
No, I was talking
As-
about statutory dedication.
No, talking about dedication, common law dedication and acceptance. I mean, my point was that if a landowner owns property, they have the general right to exclude the public. That's one of their rights, one of their sticks in the bundle of rights. Dedication is the acknowledgement by the landowner that they are going to waive that right to exclude and allow the public to access the property for some purpose. In this case, a right of way as a legal trail.
So is there a distinction between the statutory dedication that the trial court refers to in its decision?
I'm not sure I understand what you.
Well, the trial court brought up statutory dedication, and I don't know why the court did that. I'm trying to understand that. And that's why I wondered whether or not
Which page are you on,
the
Your Honor?
trial court, I don't have the decision in front of me.
Because I'm sorry, I don't recall that being an
Okay.
issue. I don't recall the court talking about statutory condemnation at all.
Not statutory condemnation, statutory dedication.
I don't recall the court
Those
discussing.
are two different things.
Yes.
Right.
And I'm not aware of even what statutory dedication is.
My memory is that it is mentioned in the trial court decision.
Well, it was never a feature of our argument before
Mm-hmm.
the trial court. It did not appear to be a feature in our, we didn't mention it in our briefs. As I would assume it is a slip of the lip, so to speak, or a slip of the pen, to the extent that it's there. But the question is, did Chittenden Marshall agree to allow public use of their property? The settlement agreement and their subsequent conduct, it's abundantly clear they did. They brought a lawsuit challenging the validity of the 1796 road. They litigated it for 2 years. Then they reached an agreement with the town. Do these things for us. Clean up our property. Discontinue some roads that we don't have any claim against from our property. Relocate this road so it doesn't disturb the meadow. Downgrade it to a legal trail. Abandon all your rights to any other ancient roads that might cross our property. And we'll allow you to use the That one public right of way, that one public right of way crossing our property will remain.
If the town was to prevail here and have this trail, and they chose to turn it into a road, reclassify it, would the landowners be entitled to compensation for such a change? Or would it be embedded within the decision that it was effectively a road prior to um, this resolution?
Dedication is always limited by the scope of what the landowner is dedicating. So this agreement acknowledges that the public right of way that encompasses this trail is going to have a certain location. It's going to have 4 rods in width. A legal trail usable for non-motorized recreational vehicles is going to be permitted within that 4-rod corridor. And the town's going to be able to take certain maintenance steps with respect to it, et cetera. That's what Fishkin Marshall agreed to. Now, if the town wants to upgrade it, the town is going to open the question of, okay, what's the fair market value of changing the use in that way? And are there any damages associated with it?
So aren't you talking about statutory reclassification? Isn't this statutory reclassification that you're talking about with the town engaged in on this road?
After the settlement agreement was signed.
Okay, so then explain to me again, because I don't think my question was answered the first time, and I may have confused you. How does statutory reclassification
Yes.
rise to an intent to dedicate by the landowner?
That act does not. This settlement agreement does. This settlement agreement, coupled with the acknowledgement that there was going to be a legal trail crossing the property,
Mhm.
coupled with attending those condemnation sessions, those reclassification sessions, attending them, not objecting, not requesting damages, all those things are actions and conduct by these landowners
Mhm.
demonstrating they intended for a legal trail to cross their property.
Isn't there also the tax?
And there was also I mean, that's part of what they got in exchange.
And that goes to your argument on summary judgment, or at least your complaint that there's also a breach of contract theory.
Yes, which
that
is not
they
before the
bargained.
court.
I know, I understand that, but that is one of the arguments, and that's like they bargained for this
Yes.
under contract, okay.
And that would be consistent with 301(8) because a trail can be formed either by converting an old road or by dedication and acceptance. And so your argument would essentially be that this, if we were to map this out, this was a 301(8)(2), which is to say dedication of a new trail for legal purposes, so that if the town changes it later on, it's not reverting to a road. It's a trail changing to a road.
Yes. I mean, and that's the deal they cut. That's what makes this case very different from Demers, was because there was no deal cut. There was expectations and hopes, and there was the landowner making a bunch of improvements to the property, but apparently harboring a desire to actually be compensated for all that work, and they didn't reach agreement on that. And that's not this case at all. None of those statutory proceedings occurred until this settlement agreement was reached. It was signed, it was filed with the court, represented to the court as the resolution for those claims, and the case was dismissed. That's when all this stuff, the statutory proceedings took place. And the town, given its position, could not stop there with this. The town needs to go through all the statutory procedures because the town believes the road's there. And so in order to preserve its position with respect to all the other landowners, it needed to take those steps. This settlement agreement makes clear that with respect to Fishkin Marshall, they had given up the fight about whether or not 1796 Road was valid or not. They agreed that a legal trail was going to cross their property within a certain 4-rod corridor along a certain path.
So Attorney Kite, are you saying that in the reclassification proceedings, that Fishkin could not have disputed dedication? Could they have raised this argument that
Yeah,
that
they
road,
could have, sure,
that
of
trail
course.
that we've agreed to reclassify was never dedicated to public use? Could they have raised that issue
Sure.
in reclassification?
And they could have raised other objections too. They could have stood up.
But
in
they
the proceeding.
agreed in the STIP not to.
Right.
Can we
And
talk about real estate title for a second? And when there was a transfer from Fishkin to the appellants, and there's a deed that they get with and all the restrictions that go with the deed. But there's no right of way that's in the deed.
Mhm.
And so how does that run with the land then if it's not in the deed?
The location of this legal trail is well documented. It's in the land records. It's recorded in the statutory proceedings. The landowners that sold it to the appellants was aware of the settlement agreement, the proceedings. They mentioned the dispute to the appellants. The appellants knew it existed and it was out there. Whatever they believed about the current status of that dispute, they had notice of record because everything we're talking about in terms of location and scope of the trail is in the land records.
Was the settlement itself in the land record?
No, but the survey is in the land records. The agreed survey is in the land records. But the settlement was not recorded until, I think it's been recorded late, much later. But it wasn't present at the time. But the trail itself and a record of the existence of the trail was present in the land records.
Chittenden's had a lot of litigation involving ancient roads and has since, since 20 years ago, when I was sitting in Rutland Civil Court, there were issues involving ancient roads in Chittenden. So shouldn't people be on notice of the situation that's going on up there?
Yes. But these landowners, the appellants had direct knowledge of the existence of the dispute. I mean, that by itself triggers an obligation to find out more about it, in my view.
So the only recording in the record as to the existence of the road is the survey, not because the settlement stipulation was never filed. Is that correct?
Yes, this document, the stipulation itself was not filed, but the statutory proceedings that lay out where the road's going to be, where the corridor is, and this exact survey that was agreed to, and the terms, like it'll be,
But it's not reflected in an easement. It's not reflected in the
No, it is not.
deed.
no, it is not.
Are the state highway maps in the land records?
They're a place people search.
Well, and do you
when
know
they're
if that's
concerned, but they're not recorded in the land records.
do you know if
I don't
that's a title standard to check the highway maps? You may or may not know that.
I do not know, Your Honor. But, in access is something that an attorney should search for to make sure that property has access. But I'm not sure that determining whether an ancient road has vanished or not. I just don't know the answer to that. I'm speculating at this point.
You would agree no one has used that road. Is that correct? That was my understanding. Parties both agree that no one has used the road.
Yes, Chittenden, when we had the statute that said, speak up or shut up with respect to ancient roads, Chittenden decided to speak up, and that generated a lot of litigation because people don't like the idea of ancient roads being revived. That's why the statute's in place, and that's why the town did what it needed to do under the statute. And this litigation was in fact generated as that result because the town looked around, said, okay, these are all our ancient roads. And the 1796 road was one of the roads that the town identified and said, this is important to us. It's got historical import. It goes to these locations. We're going to hang on to it. And that's what in fact prompted Fishkin and Marshall and Arendt to sue. Now, I want to go to something, Justice Waples, that you mentioned earlier about the agreement not to do things while they owned the property.
Right, the temporal issue. Yeah.
When you look at that, it is not broad. What it says is that the town is not going to attempt to change the status of any of the roads it's agreed to on these two properties, Fishkin, Marshall, and Arendt, while they own the property. That's because the town always has potential authority
Right.
to condemn properties, and the town's waiving that right. She's saying, hey, while you guys are here, we're not going to try to do anything. No promises afterwards. And it doesn't even make any sense to suggest that this would be some sort of expiration of the agreement,
Mhm.
because why would it matter to Fishkin and Marshall after they no longer own the property? The only time that kind of waiver would matter to them is while they're using the property themselves.
But it seems like there's an end date to it. The end date being when they sell, the end date to the agreement.
No, there's nothing in the agreement that says this ends when they sell. What the property says is the defendant shall not endeavor to change the status of those sections of the 1796 road within the Fishkin Marshall property as a trail for non-motorized recreational uses for as long as Stanley Fishkin and or Nancy Marshall own the Fishkin Marshall property. That's a very limited time-sensitive provision. It just says, we're not going to try to change this from a non-motorized legal trail while you're here. No promises afterward, but this doesn't say anything about the contract expiring. There's no term in here. There's no end date. There's no when we are done, suddenly all this vanishes. And it doesn't make any sense to interpret it that way, because this was a lawsuit that got resolved where the central question is, this isn't a road, you have no right to use my property. They agreed, they did. And I believe my time is
Your
probably.
time has expired. Thank you,
Thank you.
counsel. Does the appellant have any time remaining?
Appellant has no time remaining.
Please call the conclusion of the case.
The next hearing